The Supreme Court plans to review affirmative action policies in cases against Harvard and the University of North Carolina. This consideration of race in school admissions has long been a polarizing topic and has come up several times in recent decades. Any shift when the justices hear the cases later this year would set a new legal precedent. So I want to bring in UCLA School of Law Assistant Professor LaToya Baldwin Clark now to get some clarity. Professor, thank you so much for joining us. Welcome to Quicktake. There's obviously a lot to unpack here, starting with the fact that we have a Supreme Court in which 6 of the 9 justices are conservatives. What does it signal that the court has agreed to hear these cases involving Harvard and UNC, considering race in their admissions process?
Yeah, so, what the court is signaling, I think, is that after the last affirmative action cases, the court was very clear that using race as part of a holistic idea of how students should be gathered as a class for diversity's sake, that was just a few years ago. That was just in 2016. Therefore, the fact that they're taking up this case again, this type of case again, in such a short amount of time, I think really just signals the changing political persuasion of the court rather than any new evidence that has come to light about affirmative action.
Interesting. You mentioned the 2016 case. I want to go back to 2003 because the decision known as Grutter versus Baldwin reaffirmed that universities can take race into account. So I wonder, how does it lay the groundwork for how the Supreme Court justices might think about the upcoming cases that they're considering?
Sure. So the groundwork in that case said that universities, even public universities, are able to use race as a factor in considering putting together an entire class for the sake of diversity. And quite honestly, Grutter is a direct precedent for the case that is coming up right now. And so it's going to be difficult, I think, for the plaintiffs to actually make a case as to why we should change now. That precedent that has been sitting, like you said, for over 10 years. It's not clear to me exactly how the plaintiffs in this case are actually going to prevail given the decision in Grutter.
Okay. Well, what I found interesting in that Grutter case is that the majority opinion from Sandra Day O'Connor was that racial preferences would no longer be necessary in 25 years. 25 years has come and gone. Well, it hasn't yet, but it's interesting how she's framed things in a certain way, and that hasn't exactly come to pass. How do you think that will influence their thinking?
I mean, that's a great question. I think that when Justice O'Connor put that in her opinion, many people were very surprised as it wasn't necessary to actually settle that case. Now, of course, I think the plaintiffs are going to use those words when they come before the Supreme Court again. And the Supreme Court might ask themselves, how different is it now today than it was almost 25 years ago? And my answer would be, it's actually not very different now at all. I don't think that we have a new set of facts that would allow us to overturn the precedent that was settled in Grutter.
Well, a different group of people might argue otherwise. When I applied to college, for instance, being Asian helped me, or at least didn't hurt me, all things being equal. When my kids apply to college, they will be an overrepresented minority as Asians. So if you could talk a little bit about how the relationship of race and education, educational access specifically, have evolved or have changed over the last 18 years since Grutter.
Yeah, I mean, I think that they've changed in ways. This case is very interesting because it does focus on Asian Americans, where generally, when in the past, we've been thinking about affirmative action from this very black-white binary. But I think that what has happened is that Asian Americans are typically overrepresented in these universities. And that's not to say that Asian Americans don't necessarily deserve to be there. It's more of the factual point, and that we have an overrepresentation of Asian Americans in schools. And there's been some recent data and some recent studies that says even if we were to get rid of affirmative action and only look at things, for example, test scores, the actual percentage of Asian Americans that would be admitted into these elite universities would not actually change all that much.
Yeah, there was a study from Georgetown that showed that the percentage of Asian Americans would go down by 1 percentage point, and actually the biggest beneficiaries would be wealthy white men, interestingly enough, if they were to only look at standardized test scores. I know that
Sure.
your specialty, Professor Baldwin Clark, is examining race and education at the K through 12 level. And there's been a lot of concerns or a lot of talk about whether race should be a factor as well in testing into selective high schools. I'm curious to hear what you think are the common threads, the overlaps between race and education at the K through 12 level and race and education at the university level. Are these good comparisons to make?
I don't think that they're good comparisons to make, except for the fact of when we're talking about elite universities and elite schools, K through 12 schools. I would actually think that we need to look beyond just thinking about the elite schools, both at the high school level and at the university level, because Black children, Brown children, and Indigenous children are suffering in their own schools that are not necessarily elite universities. Elite universities or elite high schools. So I would argue that we need to look broader than that. Elite universities only make up a very small amount of the colleges and universities in our country. And in those colleges and universities, affirmative action is actually not a very big deal. What we should be trying to do, especially at the K through 12 level, is making sure that all of our children have an opportunity to be able to go to elite university if they choose to, and not only through the elective, the elite and selective high schools.
Yeah, legacy and athletics actually probably play a more prominent role than affirmative action, if anything. One word
Correct.
that you mentioned and that comes up a lot when talking about college admissions is holistic. Colleges defend their holistic admissions process, which is pretty much a squishy term because it can mean whatever the school wants it to mean in whatever circumstance or context that they happen to be in. Would abolishing the consideration of race mean that there is still room to consider other factors like socioeconomic background or geography that may intersect with race?
Yes, absolutely. And I think that's what a lot of the proponents of winning this case would say is that not looking at race, but why don't we look at socioeconomics? Why don't we look at geography? Why don't we look at all these other things that actually may still bring the diversity that we care about, but through these indirect mechanisms?
Yeah. And I also love what you said about how this is a very specific issue to elite high schools and elite colleges, and the world is a lot bigger than elite schools. What is interesting to me as well in these upcoming cases is the government's stance, because the Trump administration's Department of Justice supported the lawsuits, but justice under the Biden administration supports the defendant here, which is Harvard. How big a role do you think the DOJ will play in the case? Can they affect the outcome? Or maybe that's the wrong question to ask. Can they affect the arguments that are being put forth or how it's being defended?
Oh, sure. So they can submit amicus briefs to the justices that are what we call friends of the court. So these are briefs that are written by people who actually feel, briefs written by people who have some stake in the argument and want to bring up particular arguments to the court that perhaps the plaintiffs or the defendants in this case have not brought up. So yes, the court will absolutely look at those amicus briefs, especially the one, of course, by DOJ.
Okay, and how much sway will those amicus briefs actually have, though, do you think, in a Supreme Court that is 6-3 with a conservative supermajority?
I mean, it's hard to say, actually. There are some courts that will take those into account, different configurations of the court, of course, and then there are some configurations of the court that won't. To my knowledge, it doesn't seem as though the SCOTUS that now exists is antagonistic to these particular briefs. But, you know, with the political persuasion on the court right now, it's hard to see if those arguments will actually play a large role when they make their final decision.
I see. What is the timeline here for us to get some kind of decision from the Supreme Court, do you think?
So the court will probably hear this case in the next term. And then you expect an opinion maybe 6 to 8 weeks afterwards.
Okay, got it.
So I'm thinking by summer, late summer.
Late summer, just in time for the next class of kids to apply to colleges. LaToya Baldwin Clark, really appreciate your joining us to give us your take on this. UCLA School of Law assistant professor. Thank you so much.